country with me and do my introductions all the time. That was a very powerful introduction. Thank you so much for that, and congratulations on your accomplishments as well. Thank you, Evangeline, for inviting me to this conference and for putting this on. It's a very, very important conference, bringing together HBCUs who are interested in continuing to fight for justice through putting their students through law school. I'm currently and this is the first time I'm announcing this publicly, the executive director of the White House Initiative on HBCUs. I was able to cross the I was the acting director for about 2 months, and Secretary Arne Duncan just announced earlier today that I can stop acting. The White House Initiative on HBCUs was established through executive order by the Carter administration. It was renewed by President Obama, and it currently serves as a mechanism for there to be a liaison between the federal government and 100 HBCUs that qualify for federal support. There's about $6 billion that goes from the federal government to HBCUs annually. That money comes from entitlement programs like Title III. It comes from the funding that students get from the federal government to go to school. And it also comes from competitive grants and contracts across 32 federal agencies. It's our job to facilitate any process that expands that money and mitigate any challenges that might threaten that money. We work closely with federal liaisons that work for the federal agencies that are under the executive order. And they are tasked to work with us to create plans for their agencies, whether it be the Department of Justice, Department of Education, Health and Human Services, and the like, create plans so that HBCUs are fairly represented in the pool of resources that they have at those agencies. So it's very important work and very inspiring work as I get a chance to see HBCUs compete successfully for a lot of the opportunities that we have. I want to talk just very briefly about the relationship between HBCUs and the law. In 1854, there was an act that was established by Congress called the Morrill Act. This was before the Civil War ended, and it was established for the United States to advance agricultural and technical colleges across a system of land-grant universities across the United States so that we would be able to compete globally in the arena of technology, agriculture, and other sciences. In 1862, right before the Civil War ended, that act was expanded to include the Confederate States. Since the United States was in the midst of a Civil War, there was some thought as to whether or not the universities in the Confederate States would even be a part of the Union. So they expanded it. But between the time that they expanded to Confederate States and 1890, there was discussions about whether or not these these universities that are in these Confederate States should be a part of this legislation, seeing that they had segregation, that they did not allow African Americans to attend those universities. So what they did was they came up with a second Morrill Act, and this was in 1890, which was to establish a system of historically black land-grant colleges and universities. And so about 14 colleges was admitted into this program as a result of that act. And what the act did was it gave them all of the same benefits as the land-grant colleges that had been established for them. So this act of legislation is the reason why a lot of HBCUs are here today. Now, after that, we had Plessy versus Ferguson, which basically made it legal to segregate. Now, Plessy versus Ferguson, it also made it where the universities that existed, those same land-grant universities and other HBCUs across the South, it made it illegal to fund them at different levels than the predominantly white institutions. Of course, there was a lot of challenges to that, but that's how it was laid out. And then Brown versus Board of Education, with the work of Thurgood Marshall, which was at his perch at Howard University at the time, ended segregation. Now, even though segregation ended with Brown versus Board of Education, one thing that's important to understand is that the Morrill Act, which established these institutions that made them equal to the land-grant colleges, that was well before the Plessy versus Ferguson to Brown versus Board of Education. So it still made those colleges' mission remain intact. Now, today, there are new and more sophisticated ways to try to deny HBCUs of their fair share of federal and state resources. And one of the things that I want to emphasize to you all, as you all think about a career in law, is that HBCUs was established and they have been maintained in large part because of HBCU lawyers, because of legislation that happened, because of the Supreme Court, because the law is intimately connected with the vitality, the future, the sustainability, and the excellence of universities, period, HBCUs notwithstanding. There have been many laws that have been established in the past, particularly at the state level, that have threatened the foundation of HBCUs. As we come from the past into the future, one of the things that we see is that laws become more sophisticated. Laws that denied us the right to vote in the past were kind of dumb, inarticulate, unsophisticated laws. The laws that threaten our voting rights today are a lot more sophisticated. They don't even mention race. They just look at certain demographic characteristics or different things that might be associated with a demographic and make it illegal for that particular situation to vote. HBCUs are subject to the same type of interference by the state. Right now, we see certain things like performance-based funding mechanisms that happen at the state level where they will ignore certain things about an institution like the percentage of students that are Pell eligible and give these blanket type criteria saying that all universities, regardless of your composition, have to meet these certain standards or requirements. There's also things like the Ayers case, and that's where certain institutions will duplicate programs that HBCUs already have established using their resources to funnel students away from an HBCU. That's something that happened in Maryland. Maryland has a lot of very successful HBCUs, but they also have some very large, predominantly white institutions. You have predominantly white institutions like Hopkins University, which has a strong foothold in medical sciences, but they have a lot of money and can pretty much create any type of program that they want, regardless of the quality of that program. And so it's easy for a university like Hopkins to say, well, Morgan has this, they're making X amount of money through the students that they recruit for this, so let's just start this program over here and see, if we could funnel some of that resources over here. Now, the legality of that is something that we need the best and the brightest minds to tackle. And the HBCUs in Maryland successfully argued against this duplication of programs and was able to win that lawsuit. But they're still locked up in a legal challenge in trying to help, or trying to get the universities to adhere to the recommendations that was put forth by the judge. So where I want to conclude and what I want you all to think about through the different lessons and history that I just mentioned, I want you all to think of yourself as the future of the intersection of law and HBCUs. But I also want you to understand that just like the people who established the 1890s Morrill Act and the people who took down segregation with Brown versus Board of Education, your role is just as important. 100 years from now, people will look back at us to try to figure out what we did to sustain HBCUs. HBCUs will not have a future just because of what has been done in history. HBCUs will only have a future because of what you will do. Once you all leave this program, graduate from your institutions, graduate from law school, and really examine the laws of today and make sure that HBCUs can fairly compete in the marketplace, access the resources of the federal and state government, and not have the interference of the type of biased legislation that might come out that threatens our survival. So the charge is yours to establish history today. Thank you.